Good day. Welcome to our CPD On Demand video where we talk about risk management. And I'd like to introduce Megan Marott, Principal Broker and Legal Advisor at Aon. Welcome, Megan.
Thanks, Alistair.
It's a very challenging topic and one that has so much implications for professional engineers. Could you expand on the current contracting environment for consultants?
Alistair, I think the current contracting environment is very adversarial. So we find parties all looking out for themselves, not particularly focusing. I suppose a lot of people talk about the good old days when everybody used to get together as a team and work together for projects. And I suppose that had some merit considering a lot of those buildings are still standing. But if we look at the current environment, we find everybody really very concerned about their own risks. And so not necessarily getting together as a team and addressing what are the risks of this project, what are those aspects we need to be concerned about. We also find clients coming in, obviously, in the driving seat when it comes to contracting and negotiating how they want the project to roll out, not necessarily having the expertise to do so, often coming with their own experiences and past experiences, not often good ones. So that dictates a lot of the decision-making that they go through. So we might find unreasonable contracting terms, things that don't necessarily gel with what the real risk is associated with that project. So we go from one extreme to the other, either being overly unreasonable and finding extremely high insurance requirements, etc., being very stringent within the insurance environment. The other sort of extreme that they go to is sometimes to stick their head in the sand and address risk almost as if we don't talk about it, we assume that the consulting engineer takes all the risk that he's meant to. We don't actually address or ensure that the right risk management mechanisms have been put into place. So that's where we currently sit, and it's really not the ideal situation for us to be in.
Absolutely, and the obvious is clearly not that simple.
Yeah.
And there's a lot of assumption, I'm sure, from professional engineers. Could you expand on that assumption?
So I think it's really important for us to take a far more holistic approach on all of it. I really do feel very strongly that engineers need to be called in, your project managers, whoever might be ultimately running that project for the consultants, need to be drawn in at a very early stage, long before or right at the stage where clients are actually deciding what it is that they want to achieve. Bringing those experts in at that stage, if they don't already have those in-house, and consulting with them at that stage. Not just around rolling out this project and making sure the program is effective and going to be run efficiently, but then properly addressing those risks and having a look at it from a team perspective. And really assessing in terms of what are the project needs, what are the real risks of this project. What is the total cost of those risk transfers? Insurance is never a cheap thing on a project, and so sometimes those insurance requirements themselves can be a barrier to a lot of consulting firms even tendering, because the insurance cost alone would be too high for them and would double possibly their tender application. So it's very important to address those issues as well as what risk transfer mechanisms are really out there and what's going to be most efficient to ultimately deliver the project on time, in the least amount of cost or within the budget, and deliver a successful project.
And Aon, as an international organization, do you have good reference examples where you've successfully done this on global projects?
So we very often are called in if we are lucky enough to come in at the right time. To be honest, most of the time we're called in well after a project has gotten started. We have a number of large projects I won't mention, but where we have been called in, where we've actually helped them to design that risk transfer program. And that's not just around the just an insurance policy being placed, but actually addressing the risks. Sometimes a cell captive where the particular client has a particular sort of set of money that they put aside towards that, understanding how the contractor's risks package into that. Something very important that a lot of times is left out when we're discussing that project risk is the contracting system that they put into place. Very often clients use the wrong contracting system. They may appoint a consulting engineer using a contractor's document, or even worse, using some sort of procurement system as if they were, buying a roll of toilet paper, rather than actually addressing that you're dealing with a professional engineer. So that has been where we've been very effective, because we offer that additional service, that we can come in and also address what that contracting relationship needs to look like and what is most efficient, because different kinds of relationships create different legal liabilities for the parties involved.
Great. And from a large investor point of view, your large World Bank type organizations, do they have set policies in place that provide a standard for these global projects?
Absolutely. Particularly the international investors, they have their absolute standards within the contracting environment that they require all entities, any service provider, no matter the type of service, they actually require them to adhere to and accept. It's pretty much one of those take it or leave it kind of scenarios. Equally local, large entities, the likes of banks, also investment houses, etc., developers, have their standard arrangements in place as well. So it becomes very tricky for a consultant. And it becomes equally important to understand that if you're in an environment where you are unable to change many of those contractual obligations, is to at least understand their implication for you and go in with the knowledge and understand how to manage those around those requirements, even if you can't change those. And again, that's where it's incredibly important that you get the correct legal advice and be able to understand now what to do with the requirements in place.
Is contracting risk and professional risk and project risk firmly interlinked?
I think very much so. Sometimes, particularly your project risks and your contracting risks have also got a place within common law. So they're not just an invent of the contract environment. If you don't contract at all, you still have those risks. And it's therefore equally important to understand outside of your contracting and how you actually contract that those risks exist. How they are informed is very important, and to really be very sure that you have an understanding of your legal liability, because those will come back to bite you whether you've contracted in or out of them or not.
And of course that comes down to the question everyone will be asking, how much is enough?
Of course. We always, I suppose, facetiously say, how long is a piece of string? So, but it is an important question, because I think it is not adequately addressed by many projects. So when we're talking about really how much is enough, I think it's always important for us to address what is the risk. And again, it goes back to that team effort to get together and understand what is the actual risk involved with that project. Then it also goes back to what is that potential risk then specifically for the consulting engineer. And then, of course, cost is always a factor. We always say to our clients, buy as much as you can afford. Sometimes 100 million rand would not be enough, depending on the claim scenario. So it's incredibly important to address that and understand that, but it always, unfortunately, comes back to the cost implication. So it's important to have that information at hand and understand that. Equally, I think we will talk about limitation of liability within your contracting environment. Your contract becomes incredibly important in terms of managing the risk of how much insurance you need to take out. If your contract is not very specific around the insurance requirement or your limitation of liability, you then sit with an open-ended risk that is incredibly difficult to then go and purchase insurance for. So then it becomes very important. So we always say that it's important for us to weigh up the risk and the reward. No one is going to take on more risk than they're being rewarded for. Within the professional environment, and particularly for consultants, it becomes important for them to address that. Unfortunately, it is usually a slightly higher risk than it is reward. But then you are reinsuring or insuring that risk elsewhere with an insurance policy or some sort of alternative risk transfer mechanism. So it becomes important to understand that balance. And that is a thinking or something that any business needs to think about. Consultants are by no means in it to simply to improve the lives of those around us in society. They need to make money. They are businesses. And it becomes very important for them to balance those out and not put themselves at such an exposure that they cannot ever recover. We've had a number of consultants and some claims over the last while where a smaller firm had taken on, it was a mall down in Bloemfontein, and a relatively small fee, I suppose, in the grand scheme of things, but not a large firm, can't take on the potential of a 200 million rand loss on a mall. They did manage to limit their liability, so their liability limit was around 4 million rand. Shortly after the completion of the mall, one of the slabs collapsed in the parking lot, resulting in around 32 million rands worth of damage. Because they'd limited their liability, now this is not a firm that has 32 million rand capital lying around. The policy they only had in place at the time was for 5 million rand. Obviously, they went to court on the whole matter, and really, long story short, is that they were found liable. However, because of the limitation, they only had and were limited to that 4 million rand. So we can say, well, shame, the poor client is out of pocket now. However, the client should have addressed that a civil and structural engineer coming in with only 5 million rands worth of insurance is hopelessly inadequate for a project that size. So again, that whole bigger view of the project was not taken. But if we really go back to that consulting firm, they didn't have that kind of money lying around. So they were found liable. However, it was limited. Had there not been that limitation in place, the court probably would have ordered a liquidation of the company. The reality of a consulting firm is that their real asset base is intellectual. They can sell off some expensive computers, some expensive printers, but unfortunately, that's about as much as a liquidation order would get out of them. Most firms rent even their facilities and their buildings. So you would find the client not even getting much comfort out of that. So again, it goes back to not only the consultants managing their risk, but it being incredibly important for clients to have a proper view in terms of what their project risk really is and address that at contracting stage.
Absolutely. Thank you, Megan. I think that also leads us to a more in-depth discussion here on the subcontracting and joint venture environment and the philosophy around that, because as you said earlier, setting as a team up front is critical in terms of how the liabilities will be shared when it comes to a claim.
Sure. And I think what needs to be understood firstly is that clients often require sort of a sub-consulting type arrangement or else a joint venture type partner because it becomes incredibly cumbersome on a large project for a client to manage several consultants. So it becomes far easier for them to require that sort of joint venture. They have a single entity they're now dealing with, and so it simplifies their processes. If you think about a municipality running hundreds of projects at a time, can you imagine them now administering, let's say, even 10 consultants on a project multiplied over all of them? It just becomes impossible. So from a delivery perspective, it becomes required. But it then becomes equally important for the consultants to understand what is the legal liability created by that relationship. It's not as simple as everybody is responsible for their liability and we move on. So within a joint venture as well as a sub-consulting arrangement, the consultant, who is the primary to the client, would be liable for all of that risk that is associated with a sub-consultant or a joint venture. In a sub-consulting arrangement, they would be the principal consultant to the client, and so if anything went wrong caused by the sub, you would find the consultant being held liable for that. Equally, in a joint venture, there is joint and several liability. So we find that any one of those partners, or usually we find them all taken on jointly, are all responsible for the loss caused or the claim caused. And it is irrelevant who actually caused the claim. That's the very point of putting a joint venture together for the client. He doesn't have to sift through. He can take the shotgun approach and bring everybody in. The whole joint venture is responsible for answering for that risk. And then the understanding of that flows down to the insurance as well. Your normal PR policy doesn't cover another party who is not named on your policy for risks that they've caused. However, you now have this risk as in yourself as your firm. So it becomes important that your insurance policies address this. Within the sub-consulting environment, we often endorse a policy to say that your legal liability that flows from appointing that sub-consultant can be covered by the policy. The requirements on those are usually that the subconsultant also has to carry insurance, and equally important that there's a contract in place managing that risk and making it very clear what their responsibilities and liabilities are. Within a joint venture framework, same principle. Contract needs to apply, and they need to carry insurance as well. And also something that can be endorsed and adjusted within your insurance program. What becomes very important with joint ventures is that you cannot, and understanding that you cannot pool your insurance. If the client has set a 100 million rand insurance requirement for you, every single party to that joint venture has to carry that 100 million. You can't say, well, great, firm B has 90 million and I have 10, so together we have that insurance requirement. Because of the joint and several nature of it, if the client were to come against one of you individually, which he is entitled to do, and you're the guy with 10 million and it's a 100 million rand claim, you're hopelessly underinsured because they don't contribute together. So it's very important to understand those principles so that you can manage them better.
It seems like an absolute minefield, I must say. And when it comes down to these joint ventures, how is fault attributed when it comes to gross negligence as opposed to design fault?
Well, generally speaking, when we have joint ventures between professional parties, it's relatively easy to identify the negligence because the scope of works are very clearly identified. And we always encourage them, if it's not, to do so, and make sure of that. We don't often find within our legal framework that they are happy to attribute joint liability to parties, although we have seen this in the contractor-consultant relationship, where the question was more around sort of the chicken or the egg, which came first.
Yes.
Had the contractor done his job properly, there would not have been a risk. Had the consultant supervised properly, he would have identified the failures and seen them earlier and therefore avoided the risk. And because in those instances we couldn't easily identify exactly where the fault lay because of the overlap, that's where we've seen the courts come to a sort of a joint liability statement and equally apportioning damages. But you don't often see that in the consultant joint venture, sort of the purest environment, because their scope of works is so easily identified. You won't have two consultants doing the same design. There's always some sort of split on it. So it is relatively easy within the environment to identify, but it takes some time to do so.
Thanks very much, Megan. And of course, we have this ongoing debate about cross-border work, but more recently, South Africans are talking about Africa in a much larger sense of the word, with a lot of opportunities presenting themselves within sub-Saharan Africa. But again, what are the legal implications for working in Africa?
So, Alistair, what we've seen is obviously because Africa is such an enormous growing market, we've seen a lot of international interest within the African context. We have absolutely seen that sort of growth going, as well as the fact that we have an enormous and really a wealth of knowledge within our own country and expertise. We've seen a lot of consulting firms going into Africa as part of their growth strategies themselves for their firms. So they go and they set up companies there. Most of them have insurance policies that are global in nature, so they will cover work they do anywhere in the world, usually with the exclusion of North America or Canada. But what they don't always address is what are the local requirements of the country that they're operating in. Now, this is more specifically around firms that are setting up companies or setting up an office within and registering their company within those territories. It becomes very important as you would look up what are the company requirements for actually registering your company there. It's equally very important to address the insurance requirements, for example. Insurance falls as part of the sort of financial services industry, and so is usually very highly regulated in any country. So it becomes very important for us to address those issues, because if they require local insurance, they're not going to accept your global policy. And there's certain things that we as the brokers have to do to ensure that we are meeting those requirements. Otherwise, the firms could be subject to fines or penalties within the local context should they have a claim, and we could have some issues getting claims paid into those territories. Equally, it's important for us to be aware of any territories that have sanctions or embargoes against them, because it's illegal for us to trade with them. And paying a claim into that country is considering trading with them. So it becomes very important for the consultants to be aware of what sort of countries have some sort of international laws against them in terms of sanctions, etc. So those sort of things become important. And then, of course, the legal framework is vastly different country to country, particularly up in Africa. Everybody has, and Europe and really anywhere else in the world, has a very particular legal framework. And so the understanding of that has to be there as well. So it becomes very important for us not to simply assume that we can take our South African standards into the world. Absolutely we can, but we need to address not only the insurance requirements, the legal framework, particularly in the construction sector. Do they have their own sort of labour laws or Labour Relations Act? Do they have construction regulations that you need to honour? What sort of standards and codes do they apply? Because you have to apply those in country, even though you might be subject to the laws of South Africa within your company and how you operate. Those countries will have their own requirements.
So the regulations can be very diverse.
Absolutely. Some of them are very strict about it. We take, for example, Mauritius is very relaxed around the insurance requirements, for example. They don't mind you coming into country. They are very much a country trying to encourage foreign investment and bringing that sort of thing in. So they're happy for you to come and operate within their borders and utilize your existing insurances. Others are very specific about having a local policy. The problem with Africa is, particularly when we talk about specialist insurances, is that they don't have markets. Particularly up in Africa, we have this problem. So now you have to find reinsurance. So the regulator says you have to place the insurance locally. However, they don't have the insurance markets for you to actually honour that requirement. Equally then important for your broker to get involved in terms of finding an insurer locally who can place that, and we reinsure it back either into Lloyd's or into South Africa. So there are ways to manage it, but they are vastly different. And so it becomes very important for your broker to be very much a part of that consideration. Aon produces a global risk guide, so we have in-depth information about the risk management within almost every country that's worth trading in, so that you are fully informed when you're going into that territory to understand all of those things that are going to be cost implications for your business.
Of course, working in Africa or working anywhere in the world requires payment. But increasingly, even with large donor and funding agencies, there are complaints about delays in payment or even non-payment. Could you expand on that as a risk factor?
It's most definitely an increased risk. We're seeing a lot of our consultants are complaining about this aspect more than anything else, and I think it's a challenge for everybody. It's either payments or it's around the discounting issue, so we won't even touch on that yet. However, when we talk about the payments, it's incredibly important for consultants not to be shy to enforce their payment obligation or their payment regulations within their contractual context. So it's incredibly important. We find consultants very often almost shy or feel very sort of averse to having those tough conversations with their clients about paying the bills. But it absolutely has a knock-on impact into the project and into future costs. Consultants often are not necessarily being paid what they should, understanding as well that there's a knock-on impact into training and development and all these other things that these costs need to carry as well. And so we find consultants really on the back foot when it comes to these sorts of things. So it becomes incredibly important within your contract to make sure there are payment terms, ensure that you enforce them, because if you give the client a little bit of leeway once or twice, you create the impression that now they don't have to pay on time and that you won't enforce your payment terms. Equally important within your payment terms is not to allow for set-off clauses. Set-off clauses allow your client, should they feel there's a claim or that they're not happy with any particular aspect, they can simply set off your fees against whatever they believe their losses are. The problem with this is they never have to prove their loss. They never have to prove the claim against you. They simply set it off, keep the money, you're out of pocket. And because you've allowed for the set-off, your insurance policy can also not ever respond because there's never a claim. So the consultant really sits in a tough spot with that. And they're unable to enforce their payment arrangements in terms of their contract. So it's important for us to make sure that they are there for starters and then to actually enforce them. We've seen this quite a bit in the last while. We've probably seen around a 20% increase in the number of projects where consultants are not being paid at all, never mind on time. I'm sure the number is far higher in terms of the on-time payment. Equally, clients are very offended if you ever ask them for payment guarantees. Yet you can understand where consultants are coming from.
When it comes to disputes and resolution, how would you recommend approaching that from a claims avoidance point of view?
Sure. I think, first of all, it's incredibly important for us to understand the enormous cost involved when disputes arise. Whether it's a small dispute that we can simply negotiate and move on from, or whether there is a real dispute on the project or something that's gone horribly wrong. It's always an enormous cost involved. And so it's incredibly important for us when we, again, going back to the contract and start at that point when we're setting up our relationship, is that we account for the eventuality that sometimes something might go wrong and there may be a dispute or a discrepancy. So we always recommend that we have some sort of what we call alternative risk transfers or resolutions, which is things everyone's very familiar with. So the first is almost talking to some sort of settlement, and at whatever level you set that at. So some contracts might be set in place where we say the CEOs of the companies, if it's become serious enough, need to sit down and come to some sort of settlement. If that doesn't work, you then move on to a mediation, or if you're using the NEC contracts, talk a lot about adjudication. Important here is that you're bringing in a third party, but that third party, unlike an arbitration, that third party is not there to make the decision for you and create a binding judgment. They're there to simply try and help the parties establish some sort of middle ground, compromise on the matter to resolve it. If that doesn't work, then of course the next step is usually arbitration, and we take it to that level then. The reality, unfortunately, is that arbitration too can become expensive and time-consuming. We've had a particular matter that ran to 42 million rand in legal costs, and it was an arbitration, it wasn't litigation. So it becomes important just to understand what is within your control to actually put into place. Of course, what we're trying to avoid is running to litigation every time we have a problem, because truly once you go to court, nobody wins, regardless of the judgment. It becomes incredibly expensive. We calculate around 20 to 25% of your total cost of a dispute is just to legal costs. So it's important to have alternatives available. Some people are also more comfortable with a particular aspect. So some people have found that mediation is the answer, and that's all they want in their contracts. It's absolutely fine, but it's important to have something in place. It's also important to understand you can very much control and manage a lot of that. Not just to have a mediation clause, but to put timeframes in place. Very often we find one of the parties delaying the process by not bringing the correct papers forward, by not introducing the next action. And so put into place timeframes between you and your other parties so that you are very clear about how long you have to deal with matters. Because ultimately a dispute arises mid-project. You don't have the time to stop everything, finish your dispute, come to some sort of resolution and move on. And of course you have reputational issues with that as well. So it's incredibly important to put those aspects in place, select those. Important to remember as well is that if you have dispute resolution clauses in place, it would be a breach of the contract not to follow them. So your client cannot suddenly decide he doesn't like this arbitration as an option. He's going straight to court and taking the matter, unless it's for urgent relief. So there's something in particular that's very urgent that it be resolved. But generally speaking, the parties have to follow those mechanisms they've put in place or they'd be in breach of contract.
Right. And this, of course, has implications for jurisdiction, doesn't it?
Sure. Something very important to understand, and sometimes very much overlooked within the contract, is the jurisdiction of the contract. Jurisdiction of your contract can be dictated to very differently to simply where the project is. So it's not always about geography. Very often we find that, particularly if you've got those foreign investors, if your client is an international company, they may want the jurisdiction of the contract even though the project might be happening next door to your offices. They'll want that jurisdiction to be within the territory that they understand. So, for example, if you have a UK business, they may say to you they want the UK jurisdiction to apply. Now, most PR policies would be worldwide, with the exclusion again of North America. However, Something else to think about when you're dictating that jurisdiction is to understand that should a claim arise, the dispute would be handled in the UK. You would have to appoint attorneys or solicitors within the UK context. You're paying in pounds or euros, depending on which side of the Brexit you're on. And so there's enormous cost involved to that jurisdiction being outside of South Africa or some sort of local context. Equally important is to bear in mind the exclusion for Northern American countries. If you are working, for example, again, if it could be within Bryanston, it could be within Johannesburg, but the client has dictated that the jurisdiction is USA law, so it would be specifically in New York or something of the like, you would be sitting without insurance cover because your policy specifically excludes it. So that's why it's not just about the geography, it's very specifically around what that contract says. Now, equally important is what if the contract is silent to jurisdiction? If you have an American client, for example, again, they're possibly paying you in dollars, they are domiciled within the US. The balance, when we look at jurisdiction, we look at the monetary jurisdiction, so it's US dollars. One of the parties is US, so the balance is starting to sway to US jurisdiction. And you may find yourself still uninsured because of the implication of interpreting now the contract because you have not been specific. So it's incredibly important for us to address that aspect and make sure something is in place. Something else to consider within the jurisdiction question is to understand how judgments work. So courts of law don't have jurisdiction or don't have any power in other countries. So if we may very well agree to the client, yes, the UK law will apply, but if they get judgment in the UK and you don't have an office there, you do not have assets to attach, how are they going to establish jurisdiction and enforce that settlement or that final judgment against you? So the practicalities are sometimes overlooked by the client because they're so adamant that they want their own jurisdictions applying. But practically, they could never enforce the judgment because you're not there. Unless you decide to go and visit and buy a house there, they might be able to attach your house, but that's about all. So there's a lot of practicalities that need to be considered around the jurisdiction issue and just be thought of.
And where there are multinational companies involved on a project, for example, in Africa, do they agree on a jurisdiction for disputes?
Usually what we find is that the client dictates that jurisdiction, and should he decide on a particular jurisdiction, he would do that across the entire spectrum of the professional as well as the contracting body that they're using. It's far simpler for them, particularly if you do have a dispute that lends itself to not entirely being sure, is it a design flaw, is it a contracting flaw? And so you would usually find the jurisdiction being the same.
How important is communication? It sounds to me as if this goes to the roots of a lot of the challenges and perhaps is a solution to avoiding a lot of
Alistair, you'd be horrified at the number of claims that are less about technical flaws and more about not properly communicating with the client about, probably our biggest area of or number of claims of late have been around cost overruns or consequential losses type claims. Cost overruns is about communication. Very often it's not communicating properly with the client about the cost implication of the changes to design. I mean, this goes from, it doesn't have to be a big complex project. You can be renovating your home and, the wife decides 500 times over to change the tile design. There's a cost implication involved that if not properly communicated to your client and not particularly addressed within the contracting context becomes a problem. So a lot of your contracts will say that any changes that are going to impact, particularly on the budget or on the overall project, have to be communicated and agreed to in writing. But very often you think that because you've had the conversation or because you were in a meeting with the client and discussed it, that he's approved it. He hasn't, and you haven't adhered to the contracting requirements for it to be in writing. So the communication issue has become enormous. The miscommunication, again, when I talk about the ideal world where we are working as a team to deliver a project, doesn't happen. So the communication, even because, again, we're so adversarial and so trying to ensure that our backs are covered, we don't talk enough around and communicate enough around projects, what the issues are, and highlight those if we see them. We very often see consultants fully aware that there might have been an issue, but too scared to talk about it for fear of the finger being pointed in their direction, so it doesn't get dealt with at a stage that could be relatively low cost, no impact to anybody else, reputational risks are covered, and we leave that to explode into a much, much bigger claim. So it's absolutely a trend we've been seeing, and it all comes down to that communication.
So what are some of the more common misconceptions about PI insurance from design engineers?
Yeah. I believe that many of them feel it's a bit of a catch-all. It's an ATM, and particularly the clients actually feel this way, that as long as there's PI insurance in place, everything is fine. As to understand that it's a negligence-based policy, it's also a third-party policy. So an engineer cannot claim on his own policy. There has to be a third-party claim and a third party that suffers the harm. Equally, it has to be negligence-based. So there has to be a proving of the negligence against the consultant before that policy is going to respond to any type of claim. And very often the clients think that they can forego that element and simply make the claim and the money just gets paid out. The reality is that professional risk claims are complex. They're not sorted out overnight. Even if the client or the consultant is very clear about the damage caused or who was responsible for it, we still see it taking quite some time, particularly because most of the time that risk or that claim would fall into or being subject to now our legal context, where it has to be legally proven. That's the requirement. And our legal system is a little slow in the works. Hence, I mentioned the alternative dispute resolution options. So it's very important that we have those in place and that we use those, because of the time that it takes, because it's this misconception that you simply make the claim, somebody pays you out a sum of money, and the world moves on. But unfortunately, there are complex matters, and they have to be properly dealt with.
And is there a limitation on the time for claiming?
Absolutely. So again, going back to talking about limitation of liability, limitation of liability can be limited in one of two ways, either in terms of a monetary amount, so the actual quantum being claimed, so that's where you see your sort of twice fee or a fixed amount being put in place. The other is in terms of timeframes. So the standard or the common law applicable is that any of those claims would be subject to the Prescription Act. Very simply, the Prescription Act says that you have 3 years from the time you become aware of that claim to put that claim in. If you haven't done so, your claim becomes unenforceable. Now, the difficulty particularly with that is, when do you become aware of a claim? Because you may only suffer that harm in 10 years' time and then only have 3 years. So it's quite extensive in nature. So you start to find that the common practice now, and this is worldwide, you find it in all of your standard forms of agreement, that a limitation in time is put in place. Usually that is anything between 3 and 5 years, and it runs from practical completion or termination of your services or of the agreement. So that is your time frame. It runs from the end of the project, and you have 5 years. We find that relatively reasonable. We have not seen an engineering or consulting engineer's claim arise more than 5 years after a project is completed. Design flaws usually come up relatively quickly and quite soon, if not during the project, relatively soon after. Equally, some contracts require 10 years. There are some client bodies sort of within the public sector space that require a 25-year liability period. Nothing you can do about those. They are what they are, but you have to deal with those. But at least then you have a time frame that you can say, right, I have this insurance limit, I require this amount of risk cover for this period of time, and you can better manage it in terms of that.
So just in terms of my understanding, is each insurance policy project specific?
No. So most of your professional indemnity policies are on an annual basis. You cannot buy an insurance policy for 3 years at a time, although some clients might require proof that it's for 3 years. We can't do that. So they are on an annual basis. It's obviously subject to any claims that have risen in the year. The renewal is based on that, as well as what sort of fees you've earned in that year. It is possible to purchase PI policies on a project-specific basis. It becomes very expensive. Project-specific policies are not always as comprehensive as your annual program. So, for example, most project-specific policies would exclude cost overruns. They would exclude consequential losses. And so, particularly for a project manager, QS, that single project policy is excluding probably the biggest portion of his risk. And the likelihood of his claims are excluded there. So where the clients have taken the decision to take out a single project policy, it's usually because it's a very high-risk policy, a program, and it's particularly important for them to ring-fence the risk. They want to make sure they're in control of it. So you'll find them taking out limits of 250, 300 million rand, and there the consultants are actually liable for the deductible should they cause the claim on that. What's important there is that we then again structure those all together, because what happens is if I as the consultant are responsible for that excess, which could be 5 million rand, I don't have that in pocket. I want my PI policy that I'm paying for anyway to respond to that. So we would put in place that their PI policies are actually acting as what we call a deductible in full, and will actually respond to paying the deductible for that overarching policy. If we don't do that, it's just important to remember that you cannot take out two insurance policies, particularly within the indemnity space, to cover the same event. First of all, you wouldn't because it's so expensive, but you do have that within the legal framework. So again, it's important within your contracts and with your discussions with your broker to clearly identify that such single project policies do exist and how your two policies are meant to act together. Otherwise, you find the non-contribution clauses cancelling policies out. Because they actually have that overlap and those exclusions.
And for PI policies, it sounds as if most things are covered, but what is specifically excluded?
So I think it's important to understand that the PI policy is very specifically around professional negligence. So anything contractor related, repairs, installations, maintenance, all of those kinds of aspects, if you're getting into those, are not covered by a traditional PI policy. And there are two aspects. If you are simply on a sort of an administration side, so the relationship again becomes important in terms of the legal framework. If the relationship is around administration of a contractor type risk, we can put into an element called design and construct. So that just picks up sort of any overlap from there, even though the actual construction risk would be for the contractor. If you are actually acting as a contractor as well as an engineer, which happens quite frequently, it's very important to understand there's an entire different risk program in place for contractors. And we need to put those in place specifically for that element of risk. So that's very important to understand. The other aspect that's not covered by PI policies, fines and penalties cannot be included, cannot be covered by any insurance. So it's important to understand that if those fines or penalties are levied against you, those have to come out of your own pocket. The other aspect, we talk about sort of asbestos-related claims. It's against public policy to insure for those. So to a large extent, a lot of those are not covered either.
Okay, and is there something specific for project managers that they need to be aware of as opposed to design consulting engineers?
I think it's actually a very important misconception amongst project managers that they are very low risk because there are so many other consultants actually doing the work elements that carry the bigger risk. What we've seen as a trend of late is that the project managers are pulled into all claims because the client feels that had they managed their particular task and their scope of work a little bit better, the ensuing claim would not have happened. So it's very important for project managers to understand that they are usually first in line when it comes to the claims, even if they haven't actually made the appointments of all of those professionals for the clients, they still get pulled into the firing line. Equally important for them is when we look at single project policies is that the large portion of their work is not covered as consequential and the cost overruns issue, because any sort of cost overruns are often brought back to the project manager who didn't manage the costs of the project correctly or communicate those properly with the client. So it's very important for them to understand that unfortunately the nature is that at very worst case, or actually at very best case, they have to have a policy in place to cover their defence costs because they will be drawn into that claim and have to expend money in terms of defending themselves. Worst case scenario is that the claim actually falls into their laps and they have to pay and honour that.
Okay. Thanks so much, Megan. It's been a fascinating discussion and a very complex one. In terms of closing remarks, what advice would you give to the professional engineering community out there in terms of PI insurance?
Alistair, I think it cannot be said enough how important it is to get the right legal advice. Even where we're using standard form agreements that we're very familiar with, even where they haven't been altered, it's incredibly important to make sure that any risks or any changes within those documents have been properly addressed. I think we sometimes forget that the slightest word change can have a completely different impact on a risk that flows. So an example would be is if I have in place a limitation of liability, and I say that my liability is limited to twice the fees paid. If I haven't been paid by the client, my liability is 0. However, if I change that word to twice my fees payable, now it is the fee that I negotiated with the client initially, whether he's paid me or not. Just that one change in word has an entirely different impact on what I'm responsible for. Now, a lawyer would pick that up, not necessarily an engineer would, because it's not their expertise. I don't design buildings for a reason. So it's very important to get the right advice from the right people. So the legal advice is incredibly important. Equally important is getting a specialist broker involved in terms of your project. To be honest, you can buy PI insurance from anybody, but it becomes incredibly important is how it's packaged and that your broker understand exactly how and what you do on the ground to be able to properly manage those risks for you.
Excellent. Thank you very much.
Thank you.